welcome once again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Senator Francisco Kit Tatad. Good evening, Senator Tatad. It's nice to have you back.
Leslie.
It's nice to have you back with us with the Defense Chronicles. I'd like to ask you tonight, Senator, the impeachment court ruling is that no member of the House may be subpoenaed to the court. But for those who do not closely follow the proceedings, we had a member of the House yesterday in the person of Representative Toby Tiangco. Can you please explain?
Well, the ruling of the impeachment court is that no subpoena shall be issued to summon a member of the House of Representatives to appear here as a witness.
Yes.
But any member can appear on his own without the benefit of a subpoena. So this was the case of Congressman Toby Tiangco of Navotas, who became the first witness for the defense. But concerning that ruling, I have some misgivings about the correctness or wisdom of that ruling. The basic principle that the court was trying to apply is that no member of a co-equal branch of government should be subjected to the compulsory process in order to be asked to come to the impeachment court to testify. The immediate application is to the justices of the Supreme Court, whom the prosecution had earlier wanted to subpoena in order to provide testimony here. The court ruled that that cannot be done because if the justices decide to ignore the subpoena, then there would be some kind of tension between the two institutions, the Supreme Court and the Impeachment Court, and the result would not be good for anyone. So
no.
That's understandable.
Okay.
But in my view, this principle need not apply to the members of Congress because the impeachment proceedings have been initiated by the House of Representatives, and the trial is now being conducted by the Senate. So this is an activity of the Congress, which the members of Congress should be able to help, move as quickly as possible.
It is a congressional activity.
Yeah, it is a congressional activity.
Yes.
So the inhibition that should apply to justices of the Supreme Court should not apply to the members of Congress. In fact, if you read the rules of the impeachment court, it says that a senator may be asked to testify, except that if he is called to testify, he should stand in his or her place right here where he or she is sitting and not go up the witness box.
Are you saying, Senator Tatad, when you said a senator can be asked to testify, by whom? Who would ask him?
Either party.
Either party.
Either
the
party
defense or the front.
can ask that the senator offer a testimony if he or she has something to tell the court. And this is provided for in the rules. The last time I looked,
Yes.
it was there. Which means to say that what is sauce for the goose is sauce for the gander. I mean, if you can call in a senator to do that, you should be able to call in a member of the House of Representatives, especially since it is the House of Representatives that has brought the articles of impeachment to the Senate.
Now,
So this deserves, the ruling, I believe, deserves to be revisited by the impeachment court. Maybe the presiding officer can carefully consider what I'm saying here.
Now, Senator, what if one of the members of the Supreme Court, one of the justices, decides he or she wants to testify in the Senate Impeachment Court, will he or she be able to do so? I mean,
under the same principle enunciated earlier, that that the court will not require a member of a separate department to come, but if he or she offers himself or herself as a witness, then there's no problem
So
about
the
that.
same
And that's
with-
the case of
the same with any
Congressman
member of the House.
Congressman Toby Chan.
that's right.
Now, what did Toby say? I think that is important. While the court has restated quite clearly that it is the House of Representatives that has the exclusive power to initiate articles of impeachment. It is the sole power of the Senate to try and decide all cases of impeachment. Toby Chanko, on the other hand, has offered factual proof that it is the President of the Philippines that was behind the initiation of the articles of impeachment against the Chief Justice, which means that it was not the House of Representatives that exclusively initiated the present complaint. And that provokes a constitutional question, which I hope the court will be able to resolve.
And yesterday, we heard Senator Villar point out the clear difference with the impeachment of yesterday against the impeachment of today. What he was trying to say is Malacanang seems to be right behind the prosecution.
Well, the distinction is very clear. In the case of the impeachment case and trial of President Estrada in 2001,
Yes.
it was the president who was under impeachment. The pressure was all against him. In the present impeachment trial of Chief Justice Corona, is the president who was behind the initiation of the impeachment case and who is still out there trying to mobilize opinion, if not votes, against Corona.
Yes. Now, going back to Representative Toby Tiangco, was he able to establish a pattern, and he called it a modus operandi, that whereas before in the case of Ombudsman Mercedes Gutierrez, the pressure was on members of the House, and today, now at present, it's the same thing all over again. Was he able to establish clearly?
Well, I suppose that the point he made was not successfully contradicted by the prosecution. But it's very clear, the undisputed narration was that the members of Congress, about 120 or 130 of them, were brought inside that caucus room, and then they were given a PowerPoint presentation of impeachment charges against Chief Justice, and they were told that it was the desire of the President that they sign this impeachment complaint. Pumirma kayo kung gusto nyo, wag kang pumirma kung ayaw nyo, but this is non-debatable, no questions will be entertained. At kung pipirma kayo, kasama kayo o kaibigan kayo ni Pinoy, kung hindi kayo pipirma, kalaban kayo ni Pinoy. So very clearly, the pressure was coming from on high, and that was not disputed by the prosecution. And Congressman Tiangco showed himself as a very credible witness.
But we were made to believe that the PDAF of Congressman Tiangco was given to him after all. But he countered by saying that it was too late. What is the basic relevance of getting a PDAF on time for a member of the
Well,
House? Is it really important?
I think the question was asked and it was answered by Congressman Tiangco. He said yes, he got the PDAF after so many months, long after all the other members of Congress had gotten theirs. And he explained that, the delays cost him the implementation of the programs for which the PDAF was intended. Health services, scholarships, he said, they needed to be funded at the right time. And after the lapse of several months, then you had problems with these projects.
Anything else you'd like to share with us, Senator? Educate us with what's happening. Things are going fast right now.
We just heard the court rule on the case of one of the defense lawyers, Tony Roy. He was reprimanded for his statement in a press conference that there were reports of offers being made by Malacanang to influence the vote of senators on the previous issue, whether to follow the ruling coming from the Supreme Court. There was a reprimand issue, and Attorney Roy accepted the ruling of the court without any recrimination. But on the basis of this ruling, and the promptness of the court to rule against one lawyer of the defense, I'm looking forward to the court acting on the behavior of at least two members of the House of Representatives who appeared to have lied here in connection with the bank account of Chief Justice Corona. I think the scale of justice must be balanced and appropriate action, I believe, should be forthcoming from the court on at least these two instances.
Thank you very much once again, Senator Tatad. Thank you for joining us once again with the Defense Chronicles. This is Leslie.